Okay, everyone. First, a happy 250th anniversary to America, and thanks for tuning in. Now, a few weeks ago, the government disclosed on the public record that new charges might be possible in Don Lemon's criminal case, and we're not there yet, but I believe it's close because this week we have a key new filing. Don Lemon's motion to suppress the search of his cell phone. Yes, the cell phone. Don Lemon's rose gold iPhone. Now, there's no clarity as of yet what the government found on his cell phone, and maybe we won't know for certain until the new charges are filed, which Don Lemon's attorneys are trying to stop from happening right now with the motion to suppress. But we can theorize, based on the indicators, what that information probably is. Now, months ago, at the very beginning of this case, when Pam Bondi was still the AG, it seemed to me, based on her first public statements at the time, that Don Lemon was viewed as the ringleader of the church invasion. Then the arrests began, and the focus shifted to the two named leaders of the current alleged conspiracy, Nakima Levy Armstrong and Chantel Allen. Now, this week, Don Lemon's motion to suppress indicates that the search of his cell phone was based on an affidavit of the DHS investigator who sought and obtained a warrant to search call activity and internet activity on Don Lemon's cell phone for the month of January related to the city's church attack, as well as, quote unquote, other organized protest activity. So, from that statement in the affidavit, a legal theory of the case against Don Lemon begins to emerge. And it's based on Lemon's role as a popular podcaster who's built a gigantic following, 10 million followers across all social media platforms. Now, he's not as popular yet as Tucker Carlson with his more than 20 million followers across all social media. Now, Carlson is big enough to start a third political party, and he's declared he's doing that now. Now, Lemon isn't there yet, but he's one of the recognized faces in the progressive movement. He's more well-liked, certainly, than any single politician among the Democratic Socialists, maybe all of them put together. Now, that gives Don Lemon a lot of power, and there's no dispute he's using that power to support progressive causes, especially the anti-ICE protests, which are intended to change U.S. policy. It's a power grab, and with Don Lemon's platform, it only stands to reason that his communications to the various protest groups, if such communications exist, would have become viewed as communications from leadership. For example, if Don Lemon says, I'll cover protest A but not protest B might lose steam and maybe wouldn't happen at all. And maybe that type of communication doesn't exist, but if it does, and if there's a lot of it, especially if the decision is to go forward with protest C, F, and G, but not H, I, and L because Lemon is too busy to cover H, I, and L. Now, same with Tucker Carlson. He asserts he was investigated by the CIA. Now, Carlson's podcast is shown on repeat on state TV in the nation of Iran. He has some legal cover in the U.S. because of the First Amendment, but if he's communicating with Iran's government or a terrorist group, and if his communications descend into expert advice or assistance, he's at risk of potentially providing material support to terrorists, which is prohibited by federal law. Now, on to the motion to suppress. No surprise at all, Lemon asserts the search of his cell phone violates the First and Fourth Amendments and the Privacy Protection Act. Now, the Privacy Protection Act is legislation that protects journalists from search and seizure unless there's probable cause to believe the person has committed or is committing a criminal offense to which the seized materials relate. Now, that's a big caveat. It essentially puts the journalist back at square one with every other American. It resets the baseline to Fourth Amendment search and seizure law, and it resets the baseline to First Amendment law, which has never protected criminal activity, even if it involves speech, religious worship, assembly, the press, or petition. All the First Amendment rights. And let's take notice here. The Privacy Protection Act has never been tested at the Supreme Court of the United States, despite the legislation being enacted in 1980. Now, that's 46 years without a test case. In my view, because the caveat is so big, it neuters the act itself. Now, maybe that's why the DOJ doesn't even bother to brief it. 46 years. Now, if the Privacy Protection Act provided any rights above the baseline rights of the First and Fourth Amendments, wouldn't a test case have gone to the Supreme Court by now? Now, the search warrant application for Don Lemon's cell phone allegedly is overbroad, as it seeks call activity and internet activity on his cell phone for the entire month of January 2026, when Lemon's attorneys say there's no evidence he knew about the planned attack on City's church until the day before. Now, the attack occurred on January 18th, so they're saying that searching for evidence of quote unquote other organized protest activity on his cell phone is overbroad. Now, Lemon also says the search warrant application alleges that the DHS investigator knew the cell phone was in California, where Lemon was arrested, but allegedly, intentionally, or recklessly swore in the affidavit that the cell phone was in Minnesota at the time. Now, that's a jurisdictional defect. The magistrate judge who signed the warrant has jurisdictional limits on his authority. Lemon then asserts, like Georgia Ford, whom he references in the motion to suppress, he was falsely accused of chanting along with protesters, which he says is false. Now, he also said he didn't block anyone from leaving the church, but in the videos that I watched, he seemed to be a physical obstruction that impeded the exit of some of the churchgoers unless they relented and talked with him. And Lemon's audio stream approved of actions that caused children to be traumatized. So, Lemon is demanding a suppression hearing, and he'll get one, I believe. The government probably will present testimony from the officers who executed the warrant, saying that they acted in good faith on the warrant, because it is signed by the magistrate judge. Now, if the warrant is defective, it blew right past the magistrate. The Fourth Amendment's purpose and the purpose of the exclusionary rule, which prohibit use of unlawfully seized evidence against the defendant at trial that can be used to impeach his testimony, the purpose is to deter unlawful searches and seizures. Now, if the officers acted in good faith, however, there's no deterrence effect in applying the exclusionary rule, so the evidence can be used. Now, the good faith exception is recognized in Minnesota and California, but there are numerous exceptions to the exception. 1. The officer presented intentionally or recklessly false or misleading information to the magistrate to get the warrant. 2. The magistrate rubber stamped the warrant and didn't actually review the affidavit. 3. The warrant is so lacking in probable cause that no reasonable officer would have relied on it. And 4. The warrant doesn't even describe the place to be searched or things to be seized with reasonable particularity. I anticipate there will be a suppression hearing for Don Lemon's cell phone, but there are 38 defendants, and every one of their cell phones were seized, apparently. So that's a lot of suppression hearings. The government's efforts have been tremendous so far, and there's a lot of work ahead, apparently. Thanks for watching. And to everyone watching this video, happy 4th of July and happy 250th anniversary, America. If you enjoyed this video, leave a like, and don't forget to subscribe.